Everyone here at Pacific Legal Foundation is incredibly happy after the Supreme Court's decision in Sackett versus Environmental Protection Agency, in which the court unanimously rejected the EPA's position that Mike and Chantell Sackett should not have their day in court, and instead the court affirmed the position that PLF has been advocating over these last 4 years on behalf of the Sacketts, namely that when the government takes away your property, you have a right to your day in court to contest what the government has done. Now, the next step is the Supreme Court will send the case back to the District Court in Idaho, and we'll pick up where we left off back in 2008 when the District Court dismissed our lawsuit. We'll now have a chance to go to the merits of the Sackett's case and to be able to argue that EPA has no control over the Sackett's home building because there are no wetlands on the property, and therefore the compliance order that EPA issued against the Sackett's is null and void. This case has tremendous ramifications not just for the Sackett's, but also for the rest of this country. EPA issues from 1,500 to 3,000 compliance orders every year. That means that there are folks like the Sackett's throughout this country who have been just as much bullied and have had their property rights taken away as the Sackett's have with EPA. This decision, though, will give those folks an excellent opportunity to fight back against EPA's abuse. One important point that came through loud and clear with the Supreme Court's decision in the Sackett case is that the Supreme Court recognizes the Clean Water Act is not being effectively and appropriately administered by the EPA and the Army Corps of Engineers, and that the situation ultimately cries out for congressional change. Both the opinion by Justice Scalia and the concurrence by Justice Alito made clear that the regulated public cannot reliably know whether their land is covered by the Clean Water Act, because frankly, area that is completely dry might very well be deemed a wetland by the EPA. And so that is an important point to look out for in the coming year, whether Congress does respond to the Supreme Court's call to fix the situation. It's particularly gratifying when the Supreme Court issues a unanimous decision overturning the lower court. It's even more so in this case because every lower court to have addressed this issue, whether one can seek judicial review of a compliance order, every lower court had ruled against the position advocated by Pacific Legal Foundation, advocated by the Sackett's. That, however, did not stop PLF. It did not stop the Sackett's from fighting back, fighting for liberty. And it just gives further confirmation to the appropriateness of what I consider to be PLF's de facto motto, which is, we never give up. It doesn't matter how many lower courts rule against us. If there's a point to be made in favor of liberty, you can count on Pacific Legal Foundation to make that point, and as the Sackett's case so admirably establishes, to win on that point.